and welcome to a Newsflash episode of Unpacking the Case, the podcast by Davitt Jones Bould, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape. Hi, Richard.
Hello, Lizzie. It's almost Easter.
It is. We will very shortly be eating Easter eggs and having a nice long weekend. But before we do that, we're going to be talking about the law of encroachment in relation to leases, which actually sounds far more fun than Easter eggs. And in particular, a recent first-tier tribunal decision in McGee and Long Term Reversions Harrogate Ltd. So do you want to start with some of the background law around this?
Yeah, it's a complicated one, Lizzie, and I think it's just got a bit more complicated. The case is only first-tier tribunal. It's from February the 18th, but I was only really percolated through a few weeks later. The background, I mean, going back in history, back into ancient times, encroachment is basically where for these purposes anyway, where a tenant under a lease either encroaches on some third party's land, some neighbouring land of a third party, not the landlord, or on the landlord's land. And the case law goes back to medieval times, and mainly to do with law of manorial waste, which I won't bore you with, Lizzie. But there was a case called Kingsmill and Millard back in 1855. We're not talking about recent things here, which seem to apply it more generally, and quoted various other kind of older cases. And so there was a case, Andrews and Hales, in 1853, which gives the idea of encroachment, where the tenant under a lease encroached on not the landlord's land, but a third party's land. They built on it. So they built a bakehouse and offices, been there for 20 years. And the landlord then served notice to quit on the tenant. And it was decided basically that the notice would apply to the neighbouring land as well. The land with the bakehouse, the tenant couldn't keep it separately. And it's based on the law of estoppel, or seems to be based on the law of estoppel to some extent. Landlord is stopped from denying the tenants' rights during the lease, but the tenants are stopped from denying the landlord's the rights when the lease comes to an end. But during the lease, the tenant could apply to have the encroached land within their title. There'd been another case called Tabor and Godfrey back in 1895, where during the lease itself, the tenant had encroached on the landlord's land, and the landlord wanted an injunction. And they brought in the sort of time periods, limitation periods. The tenant had been there on the landlord's land, possessing it for 12 years or more than 12 years. And the landlord couldn't get the injunction. The landlord will be entitled to the land back at the end of the lease, but not beforehand. Again, like an estoppel, but it starts also to sound like adverse possession in that respect. And that's what the problem's been. Is it an estoppel claim? Is it adverse possession, or a branch of adverse possession? And it's very, very complicated, but I won't bore you with that.
Why is it significant then whether there's a claim for adverse possession or encroachment?
Yeah, well, the other thing is they seem to have sort of, in the concept of encroachment, they sort of brought in, limitation periods, the same limitation periods as for adverse possession under the Limitation Act. But we've talked about adverse possession a lot lately, Lizzie. But
we have. What
we haven't really talked about in recent cases, we did a case very recently on it, Kirkman, Bradshaw Pub Company, is what about claims for adverse possession from when the Land Registration Act came into force, if the titles were registered, October the 13th, 2003, the 50th birthday of the then Chief Land Registrar, if you remember. There's no limitation periods. I think it's Section 96 of the Land Registration Act got rid of the Section 15 Limitation Act of 1980 for new claims arising in registered land from October the 13th, 2003. But you can make a claim for 10 years. But if the person you're claiming against, the registered proprietor, objects, then you have to show one or more of three types of adverse possession apply. And the one which is the commonest and the one which is relevant here is where there's a reasonable mistake as to boundaries. There's got to be a boundary. You've got to have it joining that land. And the boundary has not been settled under Section 60, subsection 2 of the Land Registration. Actually, both sides can apply for so determination of where the boundary actually is. And it's got to be a reasonable mistake. Now, if encroachment is an estoppel claim, the argument goes that none of that applies once you've got your 10 years. I'm not sure how the 10 years creeps in, by the way. But once you've got your 10 years, you don't have to show there's a reasonable mistake as to boundaries and the likes. So it would be an easier claim to make. There'd been a case, which is not exactly to the point. There've been several cases over the years, but there'd been a case called Smirk and Lindale Developments in 1975. Sir John Pennycook, Vice Chancellor, who it was a High Court case. It was reversed on different grounds by the Court of Appeal, actually, but they basically said it was an estoppel claim. The Court of Appeal seemed to have accepted that on appeal. This was, I say, a High Court decision. But then there'd been a case from Hong Kong, the Court of Final Appeal for Hong Kong, which is not a direct precedent, but some senior judges listening to it, called Secretary of Justice and Chow Kar Chik Tso, which was from 2011. And the majority in that case, and it was a majority, said it's basically adverse possession. And a lot of people after that case started to think to themselves that the concept of encroachment will just be subsumed in adverse possession, and it'll wither on the vine and die. But then came this recent, albeit only first instance decision, first tier tribunal.
So, can you tell us about this case then, McGee and Long Term Reversions?
Yeah, it all took place in London. It was a top floor of a 5-story block of flats in Collier's Wood, Wimbledon Way. And the lease was Mr. and Mrs. McGee took on a lease for this premises in October 2004. They then gave their daughter a license to actually occupy the premises. Being the top floor, it had there was a patch in the roof, and they used an attic space above it. They used the attic space for storage. They reckon they would go into it 7 or 8 times a year on average, but they'd also put a ladder and lighting and boarded out for storage. And it wasn't theirs. It wasn't within the demise. It was within the landlord's reversion. And years later, well over the requisite 10-year time period, about 18 years later or more, they applied to the land registry in relation to this particular land. And there was a lot of toing and froing about procedure. But the tribunal looked at past cases, decided that Smirk and Lindale Developments was binding on them because the Court of Appeal had basically said it had correct. I doubt that a little bit myself, actually. So it was binding. And the Hong Kong case, Chow Kar Chik Tso, was not binding. And so they basically said it was an estoppel claim. And after 10 years, basically, you can make a claim and you don't have to show as a reasonable mistake as to boundaries and likes. It'd be a much more easier claim for the tenants to make. Whether it's correct is another matter, but we'll have to see.
So what are your conclusions on this one then, Richard?
It's a very, very difficult area, and cases which purport to say something if you actually look at them, and tragically I've been looking at them, don't actually say that whatsoever. And this is a first-tier tribunal case, but if it's correct, it's going to be a lot easier for both commercial and residential leaseholders to start claiming during the lease itself, against their landlord's land. Can I give you a quote? I don't usually do quotes.
Yes, why not?
But from Sir John Pennycook, Vice Chancellor, in the Smirk and Lindale case, where he said that the law on this point, if I may respectfully say so, has got itself into something of a tangle. I think it's got itself into even more of a tangle. It would be best if they just subsume it within adverse possession, at least we'd know where we were. But we might have a higher court decision in the UK or from England or Wales on it.
Indeed. All right. Well, thank you very much, Richard.
Thanks a lot, Lizzie.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.